in the matter of EOG and KTT and the Secretary of State for the Home Department.
Yes, good morning, Mr. Tam.
May it please the Court. In these appeals, I appear on behalf of the Secretary of State in both appeals, that's both EOG and KTT. Behind me and alongside me is an array of other talent. With me in EOG is my learned friend William Irwin, and in KTT, learned friend Emily Wilsden. For EOG, learned friends Amanda Weston of Queen's Counsel and Miranda Butler. And for the respondent KTT, learned friends Chris Butler of Queen's Counsel and Zoe McCallum. And then there is an intervener at the Air Centre, who's represented by learned friends Samantha Knights of Queen's Counsel and Aisha Christie. Unfortunately, Miss Knights, I understand, is unwell and unable to be here in person today, but I'm sure that she's watching on the live stream. I'm not sure whether that's to find out where I'm going wrong, whether my learned friend Christie's going wrong, but if the intervener is at some stage permitted to make oral submissions, as I understand it, the plan is that learned friends Christie will make those submissions.
Very good, thank you.
Grateful. Okay, before I start, can I just check that the court has the bundles that that have been lodged? There are quite a lot of.
Well, we think we have, Mr. Tam. I don't think that will be a useful use of time. Let's just assume we've got the bundles.
I'm grateful.
And as you will know, I use electronic bundles, so I would appreciate the electronic bundle references as well as the tab numbers, which will help my lords.
Yes. Well, I'm grateful.
Which as regards timing, Mr. Tam.
Yes. Well, I'm going to come on to that. There is a timetable which I hope was submitted to the court.
It's too long, Mr. Tam.
Well, and I hope that what I'm about to say, if your lordship will bear with me for a moment, will assuage any concerns. Can I just say a word about how we've got here, and as an introduction to how I'm proposing to advance these appeals? EOG was before this court on the 15th of July.
We know, we were there.
Yes, exactly. And it was the week. It was the week after the Supreme Court gave judgment in SC. And at that point, we applied to amend our grounds of appeal by adding the additional ground about justiciability. The following week, Mr. Justice Linden heard KTT. And at that hearing, we did have the opportunity to make substantial submissions to him about the justiciability point and the impact of SC on all of this. And in his judgment, he has considered that at great length and in great detail. So, in a sense, we have been round that particular house once already before Mr. Justice Linden. The consequence of his detailed judgment is one of the things that we have considered since he gave it. And we've reflected on the most appropriate way of proceeding with the issues in this appeal. One of the things that we have in mind is that however we do the issues, there is only going to be one hearing of this appeal. So the issues about the improper interpretation of ECAT are issues that we will have to argue in any event. Before Mr. Justice Linden, we made clear that our position, our basic position, is that we do already comply with our ECAT obligations. Now, I know that in the past, courts have disagreed with the Secretary of State on this from time to time, but that is our position. We made it clear to Mr. Justice Linden, and we make it clear again to this court that that is what we think that we do. And so none of the submissions that we make are intended to be any form of, if I can use the word non-technically, derogation from that. And so it would seem to be logical to start by addressing the meaning of the ECAT articles and the ECAT obligations, and to advance the argument that the Secretary of State does already comply with the obligations of ECAT.
I don't completely understand. I mean, this case, as I understand it, is about whether or not, as a matter of policy, Her Majesty's government has said that it will comply, has said to victims of trafficking, that it will comply with its obligations under ECAT. Is that what you just said? That Her Majesty's government will and does intend, and has at all material times said that it will and does intend,
yes.
to victims of trafficking to comply with its obligations under ECAT.
At that headline level, that is the Secretary of State's intention, yes.
Yes, but and that it accepts that it has said so in multiple fora,
Yes.
in guidance, in statutory guidance, in policies, in concessions to various courts, and it doesn't in any way seek to derogate from that position.
Yes.
And therefore, if that's correct, it also accepts, Her Majesty's government also accepts, that it is open to this court to say what that acceptance and undertaking means, in other words, what ECAT means as a matter of law, because not because we are construing the treaty, but because we are construing the policy of Her Majesty's government, which is to comply with its obligations under the treaty.
Well, with respect, my Lord, I don't go quite as far as that last step.
Right.
And the reason is this, that what the policy argument seeks in some circumstances to do is to take very general and high-level statements of policy intention, such as its intention to comply with ECAT, and in effect use that as the sole tool for imposing all ECAT obligations, whatever the court decides that they mean. That is, in effect, a sort of full and detailed incorporation of that. When taken to its logical conclusion, I know that policymakers would not do this for other practical reasons, but taken to its logical conclusion, that would result in all of the unincorporated treaty becoming something that the individual can rely on in detail, just from a one-sentence statement. And we say that in a situation like this, and this is particularly relevant to Article 14, because this is where Mr. Justice Linden ended up, that where you have a policy which says we will do X, Y, and Z, or actually perhaps it's better if I say we will do X and Y but not Z, that the headline high-level statement of policy intention is enough to have the court say, no, well, that's just unlawful. And we respectfully say that's not right, because if there is a specific detailed policy, it's taking it too far to have that overridden by general words.
Well, I mean, you are. I'm sorry. No. You have lost. I'm a simple man, Mr. Tan, and either you are saying, which I took you as having said a few minutes ago, that it is Her Majesty's government's intention to comply with its obligations under the treaty, or it is Her Majesty's government's intention only to comply with some of its obligations under the treaty. But you cannot have it both ways. And if you say, well, we don't actually want to give victims of trafficking the right to rely on every nook and cranny in the treaty, we only want to allow them to rely on Article 14, then say so. What is it? It must be one or the other, but it cannot be unclear, because people have to know what their rights are.
Well, Lord, can I pick up that last point first? People do know what their rights are. They are what is set out in the policy, where there is a detailed policy.
But let's assume, for the purposes of this argument, that the policy is inconsistent with the proper construction of the treaty. Now, let's assume that. It's not something we've yet decided, or it's been argued, but that's what's said against you. So if that were right, you would say, on this argument, that it is not justiciable by this court. What we are construing is not Article 14, but the way Article 14 is reflected in the policy. Is that what you're saying?
Lord, yes, because
So therefore, you're not. It's not your intention to comply with the treaty. It's your intention to comply with your interpretation of the treaty.
Well, Lord, with respect, I don't accept that that is a fair statement of our position. It is our policy intention to comply with the treaty, and we consider that the policy, the detailed policy that we have set out, does comply with the treaty.
Yes, but what if it doesn't?
Well, yes, if it does not, then it would follow that our policy intention, our high-level policy intention, has not in fact been satisfactorily carried out.
Okay, just take this very slowly. If it does not comply with the proper interpretation of the treaty, then it will be the case that our high-level intention to comply has not been complied with. Yes?
Not been carried out.
Not been carried out. Well, then what?
Well, the difference there is that that does not, in itself, make the non-carrying out unlawful in domestic law. That is the difference.
Well, then that unravels all you've said this morning.
Well, with respect, Lord, no, because it remains our intention. If the court finds that we haven't in fact carried it out, then that is one thing. It doesn't automatically follow that it's unlawful.
You see, but if you're right, the court will never get the opportunity to find that you never carried it out, because you say it's not justiciable.
Well, if your lordship will bear with me for a moment, can I just set out how I propose to do this? I'm on why I'm going to start with the meaning of the articles of the treaty. Because of course, if yes,
we will bear with you, but I've got to get this off my chest first, because it seems to me to be absolutely fundamental to what this court is deciding. If you are saying that what is contained in the policy, whatever it says, and whether it complies with the proper interpretation of the treaty or not, is as far as this court can go in giving effect to the rights of victims of trafficking, then that is exactly the reverse of what I put to you. Because the high-level policy is writ in water. It means nothing. And if that's the case, it's your submission, you're entitled to make it, and we will have to evaluate it. But I need to know that that is your case. In other words, it doesn't matter a fig that Her Majesty's government has a high-level intention to comply with the policy, to comply with the treaty, because it has complied with it in its own way. And it comes back to precisely what I said just a minute ago, is that it's your intention to comply only with your interpretation of the treaty as a matter of reality.
Lord, can I give a different example to illustrate the difference that we say there is between the sort of high-level policy intention statements that are being relied on by the respondents here, and the kind of policy which would, on the basis on which we approach it in this hearing, be justiciable by the court. Suppose the policy had said, we will grant leave in all cases falling within Article 14(1)(a) of the treaty, And those cases are the following, and only the following.
Yes.
You have there an example of a policy commitment of detail.
Sorry, say that?
A policy commitment of detail, or detailed policy commitment.
Yes.
Which the court may be able to judge against other materials. I'm obviously speaking hypothetically, because we'll come on to the detail of this. Against other materials, to work out whether or not that listing of exclusive categories does or does not comply with 14.1a.
And if it didn't, we would be entitled to say that the policy was what? Unlawful because based on a misdirection as to
Well, it
how
could,
do you
could be one of a number of different juridical routes.
yeah, but unlawful by one route or another.
Yes.
Yes, all right.
Well, that's what I want to be clear about. So, in your example, are you suggesting that it is open to the court to say that that policy is unlawful because 14.1a actually requires the grant of leave in circumstances beyond your categorization? Yes?
Yes, yes. Because it's a detailed policy, and if it doesn't comply, if detailed policy that says it complies or gives effect to the treaty, but the court finds that it doesn't.
Right. And do you say that about Article 14? Do you say that Article 4, that the policy says it will comply with Article 14?
No. No, no, that's right. That's a difference. This
That's the
policy
point.
doesn't. This policy says we will grant leave in the following circumstances.
Does it say, I mean, just to help me, does the policy or any ancillary materials, as Her Majesty's Government says, that it will comply with Articles 10, 11 and 13?
There are broad statements to that effect, yes.
But not
one
14.
goes all, so, well, actually, we will have to check that. I thought your Lordship said 13, was that something specifically in my mind about that?
Yes.
Yes, but can
10,
we
I think
check
it's
about
10, 11 and 13 that read together, but it
Yes.
sometimes includes 12.
Yes, I'm not sure we will find that. Certainly the policy
You
doesn't.
see, so come back to 14 then for a minute. We can't discuss the others for a moment. So you say this policy does not make a specific commitment to comply with Article 14. It has never done so. We have never done so, save by specific concession in cases like my initial PK, for example, and therefore the policy has to be looked at on its own merits, and we cannot construe Article 14 and say the policy is inadequate because it doesn't comply with Article 14.
Yes.
That's what you say.
That is exactly.
So that's a very fundamentally different submission from where I thought you were going when you started.
Well, Lord, this is why I did think that it would be helpful. I hope it still is helpful for
Well,
you
it's
to
still
sketch out
helpful.
where we're going.
Yes, it's good to know where we're going. But what I don't understand is in this somewhat, well, I won't use catchphrases, but in this somewhat parallel universe, you say the high-level policy that you have said, in other words, government generally intends to comply with its obligations, is not of any binding relevance, effectively. It's just something that governments are wont to do, and no more, really, than having ratified the treaty. because by ratifying the treaty, you've said in that general sense to the world that you intend to comply with those obligations.
Yes.
And you say that it's only if you have given a specific assurance within a policy, or external, I suppose, to the policy, to comply with particular provisions of the treaty, that you can be held to account for it in court.
Lord, yes.
Okay, well, at least I get that.
I'm grateful. And can I just say, I know your Lordship was trying not to use catchphrases, but to the extent that there is any element of parallel universes here, that is necessarily a consequence, a necessary consequence of the International Tin Council principle that, at least for some purposes, and we can argue about what purposes they are, the international law obligations into which this country has entered are irrelevant when looking at domestic law. And if there are things that are justiciable and things that are not justiciable, and there's an element of parallel universes, that's exactly where it comes from.
And it's something we all learned when we studied International Law 101, in my case, a long time ago.
Well, Lord, the advantage of having had the SC decision, as Mr. Justice Linden said, is that it does remind us that there are some constraints in this area. And it may be that on reflection, some cases have gone too far, and we respectfully say that EOG is one of them. Because when we come to look at Mr. Justice Mostyn's decision in detail, he has taken a great leap across the metaphors are dangerous, across a forbidden chasm in reaching the conclusion that he reached. And so, having had SC and having had the reminder, the argument and the analysis, we respectfully say, can revert to the lines that it ought always to be.
But Mr. Justice Linden has also taken a leap across a forbidden chasm because he has misunderstood the policy as amounting to an undertaking to comply with Article 14.
Well, I wouldn't use that term. I wouldn't use that term for that. He has, we respectfully say, erred.
No leap.
Yes, because he's taken too much from general statements when actually he should have been focusing on the policy and what the policy itself says.
Okay, well.
But Lord, having said all that, it does make sense, because I'm going to have to do it anyway, to start with what the treaty actually means. Because, of course, if the court is with us on what the treaty means, on these two particular articles, then all of the rest really falls away, regardless of whether or not...
But you say it is not relevant for us to determine what the treaty, neither relevant nor permissible,
because
in this case.
Yes, but on the hypothesis that I'm wrong on that, and I would have to address these arguments on that hypothesis because we're only going to have one hearing of this appeal, I would have to address it anyway. And so that's why I intend to start, if I may, with that. But then, before I do that, can I outline the position if the court is against us on what the treaty actually means, and there is a need to consider justiciability? I've already mentioned the fundamental principle from the International Tin Council case. I won't go back over that. But there is the principle accepted by Mr. Justice Linden, I think a sort of fairly basic consequence of that, that you cannot directly use international law obligations to fill some lacuna in government policy. Mr. Justice Linden referred to a submission that had been made by Mr. Eady, then was, in, I think, Tamil, with approval, that is something which can't be done and still can't be done because of the International Tin Council principle. But what we do say and do accept is this, that is, if a policy makes a specific provision for a particular decision-making approach to or in respect of an existing legal right, so that the policy, in effect, gives a policy promise to make the decision in accordance with an international law obligation. Then the court can require the decision maker to adhere to that policy promise.
It's more than can, it's must then.
Yes, if it finds that it's unlawful. That, I think, just sets out in legalese the position that I've reached in the exchanges with my Lord and Master of Rolls earlier. That if the policy says something and then something specific about a decision, then the court can, stroke must, hold the decision maker to that. That is, we respectfully say, in effect, where P.K. Garner got to, the Atamwan concession of P.K. Garner. And one of the things that we reflected on...
That's where P.K. Garner, I just didn't hear what you said.
Atamwan and P.K. Garner got to. Concession first made in Atamwan. It was repeated on instructions in so that's effectively where that got to. And reflecting on Mr. Justice Linden's judgment, one of the things that we noted is that after having argued, if I recall correctly, argued about what is binding authority and what isn't, he concluded that P.K. Garner was binding, even though it was on the basis of a concession. That's a position that learned friend Mr. Butler for KTT adheres to. And try as we might, we couldn't find a contrary argument to that. And if it was binding on Mr. Justice Linden, then of course, in accordance with principle, it's binding on this court. And I think that the court knows that I'm not in the habit of flogging a dead horse. And so it wouldn't be right for me to waste the court's time by seeking to reopen that before this court.
Well, what does that mean? So
Well,
what precisely is binding on us from P.K. Garner, do you say?
The principle that if there is a specific policy commitment to make decisions in a certain way, that is enforceable in domestic law. So that does not transgress the Tin Council principle. But we do say that in the circumstances of this case, it requires more than the rather high-level, general, overarching statements of intent to comply with the treaty that are being relied on by the respondents.
It seems to me what you've submitted still requires us to look very closely at the policies and the public statements by Her Majesty's government to see if you're right, whether you have in fact made specific commitments to comply with specific articles, or to see if they're right, that you've made specific commitments to comply with it all.
Yes. Well, I will be showing the court the policy in question, because we say the policy in question here is the discretionary leave policy.
You've got to show us more than the policy in question, because there are other, I mean, it all starts from section 49, and the other guidance, the statutory guidance that's been issued before the policy, I mean, I know the policies have been around for years, but one has to trace it through, logically, I think.
Yes.
I mean, that is what is missing in most of the skeleton arguments, is any logical progression through the policies, except possibly the interveners.
Well, Lord, I think our Scadden argument makes clear that our focus is on the discretionary.
I know your focus is on the discretionary leave, and you say the discretionary leave doesn't make any promises at all.
That's right.
Except to do what you want to do. but we have to evaluate, if you're right in your submissions thus far, whether you have given further clear assurances, as Mr. Justice Linden said you had, and Mr. Justice Mostyn.
Well, what I hope to show the court first is that actually the policy does comply with the treaty, or to put it another way, the treaty does not require us to do the additional things that are not in the policy, but which the courts below.
This is Article 10 and Article 14.
That's right. But before I go into the detail, can I say that there is a potential third way, which is touched on in the pleadings, and that is an argument that has been floating around that if Article 4 of the ECHR imposes obligations that are coterminous or that include the obligation, the ECAT obligations on which the respondents rely, then the HRA imposes the domestic law obligation on the Secretary of State. It's a route which I think my Lords may recall from the last hearing was floated then as a possibility, as a subject for respondent's notice. But Malone and Friend, Miss Weston's Scadden argument only touches briefly on that. And what I therefore propose to do is to come back to Article 4 to show the court that actually there isn't anything in Article 4 that adds. And therefore the third way is not one that is made out.
Yeah. You now want to deal with the construction.
Well, I promised that I would say something about timetable, because having said all of that, I think it may be clear to the court that I'm unlikely to take as much time as originally thought. The timetable allowed me today, and if necessary until I think 12 noon tomorrow, and one of the consequences is that it may well not take that long, and the remaining submissions may be correspondingly shorter.
Yes. Well, we would like to aim to finish this well within 3 days, which we think is all that is really necessary. We've done a lot of work on the papers, and for example, what you're now going to spend time arguing, namely the interpretation of Articles 10 and 14, there's only so much one can say about interpretation.
Indeed.
You say that, and they say that, and we'll have to decide. Right?
Exactly so. And hence my optimism about the time estimate.
Yes.
Can I though?
We know what you say, by the way.
I'm sorry.
And we know what you say and what they say.
Can I though first make two general points which underlie as practical realities these cases and other similar cases. We do not dispute that the Secretary of State's decision making is not as fast as it could be, and that is regrettable. It's been mentioned, certainly mentioned by Mr. Justice Mostyn at some length. I think Mr. Justice Linden touched on it as well. This applies both to decision making in respect of modern slavery, human trafficking matters, and also to asylum decision making. It's been the subject of complaint. It's not part of my brief to try and justify what is happening. It is part of the background to it. But we say that there is one important point to remember. That despite these delays, both victims of trafficking, and I include in that term potential victims, that is to say those who've had a reasonable grounds decision but not yet a conclusive grounds decision, both victims of trafficking and asylum seekers are protected in the core important ways in the interim. As the court well knows, asylum seekers are not removable while decisions are pending, and they are supported both financially and materially, so for example with accommodation. It's very similar for victims of trafficking. They also are not removable. We'll come to the detail of that shortly, regardless of whether they are or are not asylum seekers. If appropriate, they also have similar support, including financial support and accommodation. I say if appropriate because, of course, victims of trafficking are a wider group than just those who are non-British. There are people who are British, there are people who have rights to live here who may become victims of trafficking. So they may not need some of the support that is on offer, but if support is needed, it is available. And in addition, victims of trafficking also have their recovery needs met. And that includes things like medical treatment, which is available to them. It's not just emergency medical treatment, it's medical treatment, NHS medical treatment as a whole. And of course that may well include specialist treatment for those who, for example, need counselling or other help to deal with the consequences of the experiences that they've been through. So that's the first general point.
Can I just ask one question on that? I think you submitted that victims of trafficking are not removable, full stop. Is that right? Because once you've had a conclusive grounds, there may be a period later on where you don't grant leave.
Pending decision making. Sorry,
right.
This is
so you were missing out pending decision making.
Yes, sorry, that's in the context of the first point, which is regrettably there are delays, and I can't get away from that. But pending decision making.
Thank you. Sorry.
They're not removed. So it is an analogous position with asylum seekers. Likewise, if they are waiting for the decision making, they also are not removed. The second general point is this: that many victims of trafficking will have suffered gravely, and our submissions do not mean to minimise or downplay the trauma they have suffered or the consequences of that. But we do make the point that that also is true of non-trafficking victim asylum seekers, some of whom have, in some cases, sadly been through even worse experiences. The non-trafficking asylum seekers obviously have no basis for even arguing for the additional benefits for which victims of trafficking, like the respondents.
But this, I understand why you make this point, but this isn't ultimately a substantive point, is it? The truth is that, as often happens, different, though overlapping, regimes are in place, and if in some respects victims of trafficking are better treated than non-victims of trafficking asylum seekers, that is simply the consequence of the different regimes. It's not a point you can make anything of, really, is it, legally?
Legally, it only, in a legal sense, it only gets me so far. But there is a point to be made from it, which is that it is when one does these cases and one is presented with a panoply of evidence about how badly some victims of trafficking have suffered, the natural sympathy which one feels for people who have been through such experiences is liable to obscure the fact that there are others who are not in this legal regime, who may have suffered just as much, but whose protection is, other than the complaints that are made, it is otherwise unobjectionable. I mean, there are complaints of detail that are made about the way the system works, but as a matter of generality, the non-victim asylum seekers are regarded as being adequately protected during the periods when they need that protection. And the point is this, that the fact that victims of trafficking sometimes go through horrendous experiences is not a reason for abandoning all restraint when looking at claims for additional benefits over and above that which they would get if they were non-victim, non-trafficking asylum seekers. But ultimately, I accept the point Lord Justice Underhill puts to me, which is that if it's a different legal regime and they have additional rights, then that is that. But they are not in, with respect, in some exceptional category, as it is often easy to see. Can I then go to the first part of my submissions, which is on ECAT itself? Can I please ask the court to take the core bundle of authorities and go to the treaty, which is at tab 14. It starts at page 560.
I don't have it called core bundle of authorities.
Oh, sorry, it's Authorities Volume 1. Sorry, this is one of the things I was going to say. What was intended to be the core authorities went into tabs 1 to 15. I think tabs 11...
Yes, don't worry. Yeah.
Yes. Tabs 11 to 15 are in Volume 2, I think, physically. There is probably space for them to go into Volume 1, but that's how it's laid out.
So we're going to ECAT, which is in fact therefore in Volume 2.
Yes, then that is Volume 2.
Which page is it?
It starts at page 564. And the relevant part of it is Chapter 3, which starts at page 572. What we draw attention to, first of all, Article 10 is an article that is about identification of the victims. And it's within that you find Article 10.2, which Mr. Justice Mostyn relied on. But if you go back to 10.1 to look at the purpose of this article, it is going to the fifth line, so that victims can be identified and, in appropriate cases, issued with residence permits under the conditions provided for in Article 14. So you see where this is getting at. You have to find the victims, and then, if they are confirmed victims or established victims, then they may qualify for a residence permit under Article 14. So that puts Article 10.2 firmly into its place, that if there are reasonable grounds, this is the fourth line of 10.2, there are reasonable grounds to believe that a person has been a victim, that person shall not be removed from its territory until the identification process has been completed. So that's a negative obligation. And then the paragraph goes on to refer to positive obligations, which you find at 12.1 and 2, and puts it as a positive obligation shall ensure that the person receives assistance. If I can then, in order, ask you to turn over the page to page 573 to Article 12. You see the positive obligation there for victims shall adopt measures to assist victims. Such assistance shall include, and then there are a number of things listed. They don't, of course, include any form of residence permit. Paragraph 2 is another positive obligation. Paragraphs 1 and 2 are the ones referred to at 10.2. But if you go on to 3 and 4, you'll see the structure is that if you're lawfully resident within the territory, then the party, the state, has additional positive obligations.
Lawfully resident, we can treat as having a residence permit.
Yes. Or, given the context of trafficking,
Sorry,
have
where is lawfully resident?
it's paragraphs 3 and 4 of Article 12.
Sorry, yeah.
There are, of course, people who wouldn't need a positive residence permit to do so. So British citizens, for example,
Right.
many victims who are British citizens.
Right.
So they'll be lawfully resident even though they don't have a residence.
Right. So in the case of non-cits, and indeed British citizens are the paradigm example, but it would also include settled non-nationals.
Yes. So there, again, you see that the treaty is quite able to specify positive obligations and to identify the people to whom it should relate. Article 13 then provides for the recovery and reflection period, which is intended to be the period immediately after the victim or potential victim has come forward, and it starts the identification process that's referred to in Article 10. You see this because 13.1 starts by referring to recovery and reflection period where there are reasonable grounds to believe that the person concerned is a victim. And then at the end of line 5, during this period, it shall not be possible to enforce any expulsion order against him or her. So the treaty has gone back to the negative sense. And then at 13.2.
Well, just before we leave 13.1,
Yes.
the last line says, during this period, the last sentence, this period, the parties shall authorise the persons concerned to stay in their territories. I think it's common ground, but it's certainly your position, that does not mean issue a residence permit, because that's right. They mean that, they say that. But in that case, does it add anything to the negative obligation not to expel? How do the two fit together?
I knew that I was going to get asked about this at some stage. The first thing to say is that last sentence, and the meaning of it and its relation to the rest of 13.1 is at best opaque. It's puzzled both Mr. Justice Mostyn and Mr. Justice Linden. There are several ways that you could read this. It could refer, so those words during this period, could refer to the immediately preceding sentence. Referring to investigation and prosecution, as opposed to identification of victims. And in that sense, it might.
Yes, I hadn't really taken that in fact, but there is a parallelism, isn't there? Halfway through, you get a sentence, during this period, which is the rest and reflection period, it shall not be possible to enforce any expulsion order. Then you get on to the next bit, which is about effectively investigation,
Yes.
and that again says during this period. So that would suggest the point you've just made.
Yes, it's certainly a possible way of reading that.
One other way of reading it is that provision looks like a subclause to the first during this period, and then you go back to during this period, which refers back to the recovery and reflection period. Because that is what the whole article is about, a recovery and reflection period.
Yes, that's right. That's an alternative way of doing it. But before I come to that, can I just say that the first alternative, which Lord Justice Underhill put to me, would have a relationship with 14.1b, which refers to cooperation with the competent authorities, investigation or criminal proceedings. And there's a bit more I need to say about 14.1b in a moment. But that way of looking at the last sentence of 13.1
yes, I see
would have a relationship with that, because of course 14.1 is a positive obligation, like the apparent sense of 13.1. However, if that's not how that is to be read, then it is possible to read the words "during this period" as referring to the same period as the sentence in the middle of the paragraph.
Yes, quite. Well, but then it is repetitious, isn't it? Or what does it add?
Well, the problem is, well, first of all, it is repetitious, and it's difficult to see why it should be there. The second problem with it is that, unlike the choice of the negative sense in 10.2, which of course is also referring to the recovery and reflection period, and the sentence in the middle of 13.1, this is a positive sentence, shall authorize, and then that is incongruous, because as I've shown you, the treaty was perfectly capable of using, of specifying negative obligations.
Well, I see that, but you're eloquently putting out the difficulties. What is your position as to what it means?
We don't have a settled submission on this. Our submission is that you get enough from 10.2 and the sentence in the middle of 13.1. Because the one thing that it cannot be, we respectfully say, or cannot sensibly be, is the sole source for an obligation, a positive obligation to grant a residence permit.
Yeah.
Otherwise, 10.2 and the middle of 13.1 would not have said what they said.
So whatever it is can't be a residence. One point did occur to me. I just don't know factually what the position is. If you are a potential victim of trafficking, so you're in the interval between identification, between a reasonable grounds decision and a conclusive grounds decision, which might, in theory, only be, as far as the convention is concerned, 30 days, but in the real world, at any rate in this country and probably many other countries, is much longer. Do you get anything which is not leave to remain, but is some bit of paper that you can show to any one official and say, I am authorised to stay in the UK?
Can I ask my learned juniors to see if they can dig out the documentation that there is?
It would be surprising if you didn't get some. You will certainly get a letter saying you have a positive reasonable grounds decision. But whether that then specifies what your status is in this country pending a conclusive grounds decision, I don't know. Maybe we've got them in these cases, and that will show us. Could you come back to that when you can?
We'll come back to that if we may.
May I just ask one question before you leave the during this period? Your submission at the moment doesn't encompass 13.2, where during the period is used again, which strongly suggests that it's all referring back to the recovery and reflection period rather than a separate subclause halfway through.
Yes, no, I accept the place of that last sentence of 13.1 and what it means and what it relates to is okay. But I was going to come on to 13.2, which is to make a rather simpler point, that the during this period much more clearly refers to the recovery and reflection period, and then there is a positive obligation, which is in a sense repetitious of what's in 10.2, of the entitlement to 12.1 and 12.2 benefits. And then can I invite Court please to go over to 14.1. This is now a positive obligation, shall issue renewable residence permit to victims. And the use of the word victims there is important because this is referring to established victims, not potential victims. And then there is the phrase, in one or other of the two following situations, or in both. Now, the court may think that this is a slightly curious wording. It is, because when one reads 1A and B with a common law I, one might regard these as separate parallel conditions, and if either of them is satisfied, then you will get your renewable residence permit. But as I will show you when we come to the materials, interpretative materials, that is not the way in which 14.1a or 14.1 is put into practice. States are regarded as free either to provide for residence permits in 14.1a situations, but not 14.1b, or they are permitted to do the reverse, or if they wish, they can provide for issuing residence permits in both situations. Or in other words, if you as a state say that you're going to issue renewable residence permits to victims only if your stay is necessary for cooperating with competent authorities, that discharges your Article 14.1 obligation.
I must say I hadn't picked this up from the skeletons. But I'd ask you to develop the point now. Where it doesn't appear to be what it says here. Where do you? Who says it?
It's Greta, which is the group of experts, and they have, in their 9th report, set that out as a matter of principle.
They might be wrong.
Well, and then in the 10th report, they set out a couple of examples of states that have done these things.
The states might be wrong. Anyway,
well,
there we are. Okay, thank you.
Well, we make the point, and so there's no mystery about this. We make the point that one of the interpretative techniques, of course, is looking at state practice in other states. And if there's some established common state practice, that is a guide to the interpretation of the treaty.
Well, did you make this point below?
No, not this point, but this is definitely in our skeleton argument before this court.
Yes, I'm sorry if I didn't pick it up.
Just give me the paragraph.
It is paragraphs. Well, the section is 1118 to 1121. Sorry, which reminds me that it's actually also in the explanatory report, which is the next thing I have to come on to. But at this point, I think I can properly make the submission that it's an illustration of how treaties don't necessarily mean quite what they say if read with the common law I wasn't intending to go to the authorities on that, they're very familiar. But that is one of the features of looking at treaties.
So it's para 182 of the explanatory. No.
That is right, yes. 182 and 183.
Yeah. So this seems to be sort of well, I mean, it does at first sight look like a reasonable construction. Shall the obligation is to issue a renewable residence permit to victims in one or other of the two following situations, or in both, which would give a clear indication that the state can choose. And have you chosen?
Well, our practice, reading policy, is to grant in both.
Or either.
Or either,
Yes.
yes. But the point that can be made from this is that even if we do not properly comply with 14.1a, if we do issue residence permits in 14.1b, then we are not in breach of 14.1.
But you might be in breach of your policy.
Well, we might be in breach of the policy, yes. And then one would have to just look at the terms of the policy, yes, I accept that.
Well. I'm bound to say it strikes me as odd, but that may just be I haven't thought about it enough. You'll be taking us to
Yes. Well,
182 and Greta in due course. Yeah.
yeah. Well, Lord, the oddity really starts with that phrase in one or other of the two following situations, or both, because if it had simply been as a sort of the classic statutory options, you wouldn't have needed that many words. And then when you trace it through into the explanatory report and then into the Greta reports, you will see that that is, or there is an explanation for that.
Yes, but it could simply mean there are two situations in which you've got to do it, and sometimes both situations will obtain. I agree then that it could have been expressed more economically, but that would be a perfectly sensible thought. Anyway, there we are.
Other than the fact the explanatory report doesn't say that, and Greta...
Well, no, well, let's see those.
Yeah, well, can I then go on to the explanatory report, because that's logically the next place to go. This starts, it's tab 15, starts at page 594, and the section dealing with chapter 3 starts at page 614. Paragraph 124, the introductory paragraph, points out the distinction between those who are established victims and those who are what we call potential victims. So there's no oddity about some of the provisions only applying to established victims. There's then page 615, section on Article 10. Can I draw attention, please, on the next page, paragraph 131, for the negative language that's used in relation to the 10.2 obligation. 131, the explanatory report says, even though the identification process is not completed, as soon as competent authorities consider there are reasonable grounds to believe the person is a victim, they will not remove the person from the territory of the receiving state. So a negative obligation. Then it recognises that identifying the victim it takes time. And then halfway through the paragraph, many victims, however, are illegally present in the country where they are being exploited. Paragraph 2 seeks to avoid their being immediately removed from the country before they can be identified as victims. Chapter 3 secures various rights to people who are victims of trafficking. Those rights would be purely theoretical and illusory if such people were removed from the country before identification. At 132, Convention does not require absolute certainty, and skipping a couple of lines, if there are reasonable grounds, then that is sufficient reason not to remove them until completion of the identification process. And 133 makes clear that it's not only what would be called reform on asylum, but also removal to a third country. So clearly, negative language being used here about the 10.2 obligation. Can I then go on to the Article 13 section? This starts at page 621 of the bundle. 173, there's an identification of the recovery and reflection period. I don't think that the text here illuminates that last sentence of 13.1 any further. But we do draw attention, please, to paragraph 178. Words, "it shall not be possible to enforce any expulsion order against him or her," mean that the victim must not be removed from the party's territory. Although free to choose what method to employ, parties are required to create a legal framework.
So sorry, where?
Yes, sorry. Paragraph 178, top of page 622.
Yes.
So the negative language in the first sentence. Parties are free to choose what method to employ. They're required to create a legal framework allowing the victim to remain on their territory.
And then the final sentence really plugs into the query I raised earlier.
Yes, the relevant
You must be given some documents.
We'll find that.
Yeah.
And so clearly a negative obligation being expressed there about those words. And no hint that during the recovery and reflection period or any time during the identification process that there is a positive obligation to grant a residence permit. And then starting at paragraph 180 on 62 to page 622, residence permit provides that victims of trafficking shall be issued with renewable residence permits. This is now established victims and not just potential victims. And then at 182 is the paragraph that we've quoted in our skeleton argument. Two requirements.
180 is very unequivocal, isn't it?
Yes, although that has to be read with the language of 14.1 itself, which is not an unconditional requirement to issue residence
Well, I
permits.
understand that, but it's very unequivocal. Yeah.
Yes.
May just be intended to be introductory.
It is certainly introductory, and of course there is further text below that. What I asked to draw attention to is the requirements laid down in 14.1, either that the victim stay be necessary owing to their personal situation, or that it be necessary for the purpose of cooperation. The aim of these requirements is to allow parties to choose between granting a residence permit in exchange for cooperation and granting a residence permit on account of victims' needs, or indeed to adopt both simultaneously. That word "adopt" is important because it shows that is it's for the state to choose between one course or the other course, or with the freedom to adopt both courses at the same time. And that's even clearer when you look at 183.
So if you have a situation in which on the interpretation you're advancing, the state has opted only for 1B, you will have two people in identical situations, needs as regards their needs, their personal needs. But if in one case there is a criminal investigation ongoing, and the other there isn't, and let's exclude cases where the only reason there isn't is because the victim hasn't cooperated, you have two people with identical needs being treated differently on what might seem to be an arbitrary basis. In one case because there's a criminal proceedings for which they are required, and the other there isn't. You say, well, that's what it says.
If the state has adopted that, then that is the consequence. It wouldn't be arbitrary, because if the state does not and is not required to grant leave simply because somebody has a need for leave, then there's not arbitrary distinction between them.
No. Okay.
And 183, for the victim to be granted a residence permit, depending on the approach the party adopts. So again, you see that there's a choice between those two routes. I suppose between the three different routes. There's either or. And then parties likewise have the possibility of issuing residence permits in both situations. So it is, we respectfully say, quite clear from that what is happening. But perhaps it would be best, now that I've got into it, to make or to draw attention to the other materials. First of all, can I ask you to go to the Greta 9th report? Now, this is in the volume 4 of the policies bundle, and that should start at tab 22 starts at page 1508.
150.
1508. This is the policies bundle.
Ninth general report.
So that's the start of the report. You'll see that it covers the year 2019. And then if you go on to paragraph 157, it's page 1566 of this bundle. Just for background, as we understand it, Greta is the treaty's monitoring body, so it's not just a bunch of experts. It is the nominated.
It's provided for somewhere in the treaty.
Exactly. Yep. So at 157, parties can choose between granting a permit to victims on the basis of their personal situation, or for the purpose of cooperation, or indeed to adopt both options simultaneously. So that's perhaps in even clearer language than the explanatory report. And then state practice. Out of 42 countries, 22 had legislation envisaging the issuing of residence permits to victims of trafficking on both grounds. 14 granted residence permits to victims exclusively for the purpose of their cooperation. And 2 had legislation providing for the issuance of residence permit to victims on humanitarian grounds. And to flesh out some of the bones of that, can I invite you to go to the 10th report, which is the 2020 report. This starts at page 1437 in the same bundle. But the relevant part starts at 1477. The section starting at paragraph 92.
Sorry, which page number again?
It's 1477.
Thank you.
Paragraph 92 is an introductory paragraph. And then there are a number of examples given. So 93 in Belgium, the second sentence, when a person is identified as trafficked, no new residence permit is issued if the person already has a permit as part of the asylum procedure. However, as pointed out in the context of Project REST, there are situations in other countries in which residence permits based on the status of being trafficked are withdrawn once the person concerned applies for asylum, or the application for a temporary residence permit based on the status of being trafficked is rejected on the grounds that the asylum claim needs to be determined first. And then if you go on to paragraph 94... Is
that a reference to the UK at one point?
I don't know.
It doesn't say so in the footnote.
Yes, well, we'd have
No, I just wondered, so difficult to keep up with all that. I thought that was what one of our cases was about, but maybe not. I do mean our cases, sorry, one of the UK cases was about that issue. I may be wrong, doesn't matter. Don't spend time on it, sorry, I was just thinking aloud.
Paragraph 94, there's then a reference to Spain, and then in the fourth line to Norway. The recovery and reflection period is incompatible with an asylum procedure. When a victim of trafficking applies for asylum, after having been granted the recovery and reflection period, he or she might lose certain entitlements, such as work. Similarly, Swiss authorities do not grant a recovery and reflection period where there are reasonable grounds to believe that an asylum seeker is a victim of human trafficking. And then going on to page those are examples that one sees of how other states work. Which
that's not. I mean, those are interesting points, but they're not the same. They're not illustrations. I thought they were going to illustrate the point we previously seen in Greta 9.
Yes, I think I accept that. But Greta 9 does deal directly with Article 14. But they are illustrations of how different states do read these procedures in different ways. And it's the sort of approach that one finds when a number of different states are implementing treaty obligations. And in the case of Article 14, perhaps not the clearest. So that's what the treaty and the explanatory report provide. We do draw attention to the fact that the process of identification is recognised as a single process of identification of a victim. Can I just give you the authority reference for that? It's Domestic Authority of MN. It's in Authorities Volume 1, Tab 9, starting at 275. The paragraphs are paragraph 86, which identifies the issue. That's page 306. And then if you look at paragraphs 92 and 93 at page 307, you'll see that how this court...
So sorry, I misunderstood. What is the proposition that you needn't take us, but what if we look there, what is the proposition we would find?
The proposition that Article 10 identification is one single process, and it comes to an end when the conclusive grounds decision is made. Either the individual is a victim of trafficking, or they're not. So that was the basis of that decision.
So what?
Sorry, can I just say, to understand the case when you read it, you do need to look at where the issue in the case was set out, which is paragraph 86.
I remember the case well. But what I don't quite see what you want to do with this.
Right, because the thing that then comes on from that is that it does show that the period between the reasonable grounds decision and the conclusive grounds decision is an interim provisional stage.
Yeah.
And that is the proposition which is made entirely clear by MN, if it's not clear from the other materials. And so any obligations that the UK owes during that period have to be seen in the context of that being an interim provisional stage. Yes, I'm conscious that some of the submissions directed towards EOG and some of the decisions, some of the submissions directed towards KTT, but I hope that going through this in an order will avoid having to jump around and go back to the materials. Can I then show the court something of the support that is available at the different stages of the procedure? For this, probably the best place is to go to the current version of the guidance, Modern Slavery Act statutory guidance. It's in the policy bundle, bundle 3 of policies at tab 18, starting at page 1205. Now, as the court knows, this has been, this in itself is a successor to earlier non-statutory guidance, and then it has itself been through a number of different versions. That at page 1214, you'll see a sort of change log, the detail of which doesn't matter. The
and
relevant...
just so it will help me understand where this is going to. why is it material to the issues before us? What kind of support people receive?
Because it is support for my submission that during these interim stages, while people are waiting for decisions, especially between reasonable grounds and conclusive grounds, there is adequate support for them to show the court what is available.
I see. I suppose this is more open to EOG than KTT.
Yes,
That is
right.
Right.
But
Sorry,
there
I
is,
just needed to see how it fitted in.
yes. Amongst other things, that there is a particular submission that I need to deal with. I can't now remember if it was EOG or KTTs. In the absence of what they were seeking, they would only be entitled to emergency medical treatment. And while that may be all that the treaty requires, that is not what is provided here. The relevant section starts at page 1265. It's support for adult victims. And the key points headline what is available, and then point to Annex F. Before I do that, can I just draw attention to the headings on 1266 about the general principle of support, 8.7, risk and needs are assessed at various points, and then you get headings at 1267 about assessing risk on entry, and 1269 assessing need on entry, and then provision about the recovery period and journey plan and move on period. So the detail is in Annex F, page 1358, is where it starts. There's, first of all, a section about accommodation. It makes the point that at 15.1, for example, that different victims may have different needs for accommodation depending on what other entitlements they might have. Then there is a section about accommodation provided through the modern slavery contract, and then through the asylum system. Further detail about accommodation in the following pages, and then at 1363 there's a section about financial support. Indeed, in the light of the questions that were being put to me by the court earlier, can I just draw attention to the detail that there is in this section about financial support. Very specific provision made for amounts payable in certain circumstances. And as the court knows, there has been litigation about the detail of amounts.
Yes, you're awaiting a judgment on this.
Yes, that's right. A particular wrinkle that occurred there.
Yes, on a particular wrinkle.
The point here is that if there are arguments that can be made about the detail of the policy, then this is the sort of argument which could be made. It's not being made on the basis of high-level policy statements. At 1364, there's a section about material assistance. That's literally material assistance, going down to toothbrush and toothpaste.
So I didn't get the paragraph.
It's paragraph 15.41, page 1364. And then a section on page 1365 about translation and interpretation services. The court will recall that being part of Article 12. Information about rights on the next page. Medical treatment. and there's quite a lot of detail over these pages about what medical treatment is available. I don't think it's in dispute that basically NHS treatment is available if you need it, and is not limited to emergency medical treatment.
That's 1556.
And yes, and there's the whole section really, because if you go on to surcharges and exemptions from surcharges, you'll see that basically it is medical facilities are available.
Can you give me an idea of how many victims of trafficking the department deals with every year?
Not off the top of my head, but again, we'll
I
find.
mean, I'm not looking for absolute
Yes.
detail, but just to give me an idea.
Well, what I recall off the top of my head is that the number of people referred into the NRM is over 10,000 a year. There are some statistics in. I think it may be Mr. Justice Garnham's decision, but we'll dig out the detail.
Yeah, I thought I'd seen them somewhere, and I looked at Mr. Justice Garnham, so it may be there.
Yes.
I think there's some in Mr. Justice Mostyn's decision as well.
Yes, it may well be.
Of whom the great majority will not be British citizens, but a few will. And of those who are not British citizens, the majority will not have any form of right of leave to remain, but some will have. There's some subgroups like the domestic servants who are victims of trafficking who probably have got some kind of work.
You've just been given a note by your junior. No, the other side.
Yes. By 2020, it had risen to 10,613.
That's in the calendar year.
Referred into the NRM. Calendar year? Of whom 48% were adults and 34% were British.
34% were British. That's a higher number than I thought.
Serious problem anyway.
So, I'm sorry.
It's a serious problem anyway.
It is a serious problem, yes. So I don't mean to downplay.
No. Okay, well, I mean, do we need to know the detail of this document? We've got it. And we can see the detail.
Yes, well, if I can invite the court to go through the remaining headings, you'll see all the support that is available. It is far from being the case that either between reasonable grounds and conclusive grounds or after conclusive grounds decision that you need to have leave to remain in order to be properly supported. That is simply not the case here.
But just so we're clear about it, you don't, unless you are given leave to remain, and just leaving out British citizens, you don't have access to benefits, to mainstream benefit, to benefits in that sense, benefits under the mainstream system, or the right to work.
If you don't already have those rights, then no, you wouldn't apply them. Yes. But that is the same as for asylum seekers.
Of course, I understand that, but I just thought that needed to be. You were saying all the support you do get, but the other part of the picture, really, why this claim is being brought, is the ones you don't, the points you don't get. I just wanted to identify what those were.
Yes, yes, but then that of course is what claimants will do, which say I don't get this, I don't get this, I don't get this, I'm disadvantaged, and they don't show the court all the things that they are going to get get.
No, but the right to work is tremendously important to any person's rehabilitation. The right to work in the
yes.
mainstream market
Yes.
is tremendously important to any person's rehabilitation.
Well, as a general
As a general proposition.
as a general proposition, as a general policy argument, one understands that, and don't need evidence of the benefits it can bring to individuals. But the point is, I don't think I need to apologise for making it again and again, is that it is exactly the same for asylum seekers who may have been through the same or even worse experiences, and they do not have the right to work. And despite a great deal of litigation, indeed legislation about it, they don't have the
There's a slight shading to that. They do now have a qualified right to apply for the right to work if they haven't had a decision in a year.
Yeah, that's right. But there are complaints about that too. So,
I'm
that's
sure-
why I'm being
I'm sure
very,
there are.
very general about that.
Yes.
And so, I mean, in a sense, many of the arguments about should the claimants have these additional benefits are policy arguments that are properly directed elsewhere, just as the right to work arguments are properly directed elsewhere. They can be within a court dressed up in the form of legal arguments, legal entitlement to this and this. But ultimately, underneath all of this, there are social and economic judgments to be made about whether or not certain rights should be conferred. And that is an arena in which these arguments can properly be had. Obviously, there's a proper legal argument that should be here, but this is the cusp that we are on in cases like this.
I mean, this is all very interesting, but of course we do have to determine the legal claims that are made.
That's right. So I don't seek to suggest that makes it irrelevant, but it is. There are these flavours behind these arguments, and not just in this case, but in very many cases in these fields.
I mean, you say, as the government often says in these cases, that matters of social and economic judgments are matters for the government to make. And of course that's right, so far as it goes, but the question here is whether legally binding obligations have been entered into and whether they've been performed.
That's right. I think that the submission I can properly make is that the court should be careful not to trespass from one area into the other by saying that we think it's a good idea to do this, and therefore there should be a legal obligation. There does need to be a sound legal foundation.
I think you're talking to a court that gets that point, Mr. Tan. Grandmothers
I'm grateful
and
that
cakes come to mind.
I'm grateful, and I'll try not to make it again. Lords, can I then move on to the policy, because this is really the centrepiece of where we are now. That, of course, is an easy thing to say. One of the difficulties here is that we've got several versions of it. Can I say what I propose to do is to go to version 2, which was the version that was relevant to KTT and the subject of Mr. Justice Linden's consideration. We can get a flavour of version 3, which was relevant to Mr. Justice Mostyn's decision, by looking at version 5, which is the only other one I think that's in the bundle. But version 2, if I start with that for the moment, this is in Policy Volume 2. It starts at page 620 of the policy pagination. And we say, as I think I've trailed already, that one of the important things to note is what does the policy itself say? One of the things that is clear from reading the policy is that in neither situation, that's neither EOG's situation nor in KTT's situation, does it provide for a grant of leave. If it did and the Secretary of State refused it, it would be a much simpler case to bring before this court.
Sorry, say that again. Neither version provides for the grant of leave.
Yes, in the situation in either claimant's case. So on any view, what the claimants are trying to do is to extend the policy beyond what it actually says by saying that it's unlawful for a policy.
Not quite what they're doing is aren't they saying that the policy is unlawful because what it actually says is contrary to the Secretary of State's declared intention to, as they would say, in this particular respect, comply with its international obligations?
Well, the necessary.
They're not trying to extend. Well, in a sense, you can say they're trying to extend the policy, but that's a pejorative label. As a matter of legal analysis, that's not what they're doing.
Well, if it's a necessary consequence of their argument,
It's forensic. It's entirely forensic. Either you're able to show that she has done something, either they're able to show that something unlawful has been done or not.
yes.
And simply to say they're trying to push the boundaries doesn't really take the matter much further.
Well, I can properly make the submission that the policy does not provide for a grant of leave in either claimant's situation.
Well, I mean, the policy provides a number of provisions we need to understand. So let's try and do that, shall we?
And perhaps it's just a convenient time to pick up the relief. The Butler may have other views about it. I've actually forgotten exactly what the relief was, but it was presumably a declaration that the policy as it stood was unlawful for the sort of reason I've just summarised. Formally, it remains for the Secretary of State to make a separate policy, which either says, I do not intend in this respect to comply with my international obligations, or now I've been told what they are, I will comply with them. That's formally the next step, isn't it?
I think that's a consequence of the EOG declaration.
Yes, I've seen, sorry, I've been thinking about KTT, but yes.
Yes, the KTT relief went further.
I see, we'll probably...
There was a declaration and then orders, wasn't there?
Well, there was, sorry, if I've misremembered this, I thought that Mr. Justice Linden had watched the decision as well.
What pages?
He declared on the true construction of versions 2, 3 and 4 certain materials, and then ordered the allowance of the ground 1, and then quashed policy.
Yes, but the consequence of that, and Mr. Justice Mostyn was more explicit about this, the consequence of that is that you must make a fresh policy, or have no policy at all, but I don't think anyone thinks that's realistic. Those behind you will probably be aware, not necessarily the juniors, but there was a very recent case in a different field called Akinsanya, where the Secretary of State said, effectively, this is about a different kind of international obligation, EU obligations which were no longer binding. Tell us what the EU law was, and then we'll go away and make a policy in relation to it, either to decide still to follow it or not to. And that's really the same area we're in now, isn't it?
Formally, I think I would have to accept that, because formally, my Lords are right to put to me that in theory the new policy could say we're not going to comply.
You may well tell us that's very unlikely, because that's not been the stance of the Secretary of State ever since 2009, but still, theoretically, that is our choice.
Yes. In theory it is. The practical consequence I've made the submission of.
Okay, thank you. Sorry, that was a digression.
No, not at all. The policy, or the meat of the policy, starts on page 625. The heading at the bottom of the page is when to consider a grant of discretionary leave, DL. And the policy says there must be reasons based on their individual circumstances to justify a grant of DL where they do not qualify for other leave, such as asylum or humanitarian protection. And then on the next page, the second paragraph, discretionary leave may be considered where a competent authority has made a positive, conclusive grounds decision that an individual is a victim of modern slavery and they're not eligible for any other form of leave. And then one of three circumstances, leave is necessary owing to personal circumstances, necessary to pursue compensation, victims for helping police with their inquiries. So I think one cautionary thing I should say immediately is that is drafted in a way which in effect precludes the grant of DL before an asylum decision is made, if there's an outstanding asylum claim. That has changed since version 2, after litigation. I think that was JP, and so the current version of policy does not have the rule in place. Been replaced by other provisions. However, the meat of the policy remains the same, and you'll see that there are 3 headings. That doesn't automatically and immediately correspond to the 14.1a and b.
Well, 41A and the first heading is pretty similar.
Yes, and that's why we say the policy recognisably covers situations that fall within 14.1a. But this is not an attempt to just reproduce 14.1a in a policy.
Well, can you just identify what you say the differences are between 14.1a and the first heading?
We have to go on, don't you?
Well, yes, the differences are precisely what is being argued against, which is that we say, or rather the policy says, you grant leave if leave is necessary. And the claimant says, as KTT says, that you must grant leave if the stay is necessary. Even if a grant of leave is not necessary.
I mean, that's true. I mean, this reflects effectively your construction of 14.1a, but to me, anyway, the next passage is the most important under the heading leave is necessary owing to personal circumstances. And we can read it for ourselves, but it says that the decision makers should primarily assess whether a grant of leave to a recognised victim is necessary for the UK to meet its objective under the Trafficking Convention.
Yes.
So it says that the decision makers should primarily assess, that they've got to assess whether a grant of leave is necessary for the UK to meet its objective under the Trafficking Convention. So in order to do that exercise, I suppose, they've got to know what the UK's objective under the Trafficking Convention is. They've got to know what the Trafficking Convention says. I mean, it's an odd formulation, let's put it that way. You said curious, you used the word earlier. That seems to me to be quite a curious form of words.
Well, can I say, first of all, the objective is actually set out there. So the official who's making the decision will see that the objective is to provide protection and assistance to that victim.
Sorry, where is the objective set out?
It's after the
I see, to provide protection and assistance owing to its personal situation. Well, that, if I respectfully suggest, can't be the entire UK objective under the Trafficking Convention.
Well, this is why I was drawing the distinction earlier between very high-level statements of policy intention and the sort of detailed statement of policy which a court could properly try to match up against the detail of the treaty and say, no, this doesn't comply, and therefore the non-compliance is unlawful.
Can I ask you something else? I mean, I see that, but can I ask you something else? Is this formulation, those 4 lines that I've read out, are they reflected in all the other documents, or do we have to worry about these having changed?
I don't believe that this has changed.
Well, it's something for your junior, rather than you to check. One of your juniors, I'm sure, can check that, but
Yes.
you don't think it's changed?
I don't believe that has changed.
And you say this is not a high-level agreement to comply with the whole of the Trafficking Convention. It's merely a statement of a minimalist objective to provide protection and assistance to the victim owing to their personal situation, which is very modest indeed.
But just so we don't get hung up on terminology, I think in your language this is high level. The reference my Lord has taken you to meet its objective under the Trafficking Convention, you say is high level and unspecific, can't be taken as a statement that we are going to comply with 14.1a precisely as drafted. This is how we're going to do it. The words after the dash.
Exactly, yes.
And sorry, just to fill in one small point, but feeding off my Lord's point, if we go back to 623, there is an explicit link to ECAT. Is that not the case? At the bottom of the page, related external links, one to PK Ghana and one to ECAT. So,
yes.
In theory, I don't suppose this is really how it would work, but in theory, the decision maker saying, I see I've got to do what's necessary to meet the objective under the Trafficking Convention, is given the tools in which to go and see what the Trafficking Convention says.
That is right, but the paragraph there, the bullet point there itself, identifies the UK's objective.
Yeah.
But it is, and may I respectfully adopt the point the Lord put to me, this is an example of one of those general high-level statements of objective. What it doesn't do is to say decision makers should assess whether Article 14.1a requires a grant of leave. I mean, obviously, that's not the only way of drafting that, but it doesn't say anything along those lines.
Well, you do need to deal ultimately with the way in which Mr. Justice Linden said it meant that.
Yes, and when I come to make the submissions on each of the cases, which might be quite brief by the time I do it, I'll address that. We do draw attention, though, to the way that the examples are listed. I accept that they are examples because the policy itself expressly says that the list is not intended to be exhaustive. I'm going to skip over the first one. The second one relates to a significant and real risk of the person being re-trafficked or becoming a victim of modern slavery again. So, if one is looking for the character of that kind of situation, it is what one might describe as a substantive need for leave.
Why would having leave, in circumstances where you are already irremovable and have the various sorts of protection which are required under Article 12, make a difference?
Because this relates to the time after the conclusive grounds decision. So the decision making has been completed. The temporary irremovability under 10.2 and 13.1 has ceased. and this is looking
Yes, of
substantively.
course. No, that's well. That is an answer. Yes. Okay. Thank you.
May I ask just one question on this? The difference between stay and leave, which you emphasise between the wording of the treaty and the policy. If a person needs to stay in this jurisdiction and has no right to stay because the conclusive grounds decision has been made, will they not also need leave? Because otherwise they're here illegally. And so what is the difference between the treaty and your policy? I suspect the person who drafted the policy thought that they were just giving effect to the treaty once you had a conclusive grounds decision.
The difference is this, and this goes back to the. I should just say for clarity, this is of course KTT's case.
I understand that. Yeah.
The claim being made by KTT before Mr. Justice Linden was not, I have received a conclusive grounds decision and I need to stay here long term, so, or substantively, the adjective I've just used. So please may I have a grant of DL in accordance with the policy because I need it for one of these reasons. Originally, that was the way it was put. By the time we were before Mr. Justice Linden, it was different. The claim was, I have applied for asylum. There is going to be a lapse of time before the asylum decision is made in my case. I can't be removed while my asylum claim is under consideration. Therefore, my quotes stay, unquotes, is necessary. Therefore, 14(1)(a) entitles me to a residence permit, and therefore, this policy, the analysis, this policy is unlawful because it does not provide for that.
Just to spell it out, I'm sure it's obvious. In principle, that leave would, that they were asking for, what the same policy should provide for, would go only up to the moment of asylum decision. If the Secretary of State's procedures meant that it was for a fixed period, and the asylum came during that period, that's only because the Secretary of State chooses to give them in 6 month or 12-month intervals. But in principle, you could say you can have leave up to the moment of the asylum decision.
Yes, subject to whether that's a permissible limitation under the Immigration Act. But it's probably an argument for a different case. But I understand the point the Lord is putting to me. In principle, that is the kind of leave for which KTT was asking.
Yes.
And that's why it is different in nature from the kinds of leave that the policy contemplates.
Funny, and the sorts of questions you'd be asking under your bullet point 2 would be very like the sorts of questions that the Secretary of State, or in due course the FDT, would be asking when making the asylum decisions.
That's right. And that's one of the reasons why originally there was a rule, DL decision would not be made until asylum had been granted, and now there's presumption that will be the case.
So, I'm trying to understand this. This policy is addressed really to giving permanent leave to remain after a conclusive grounds decision. And the first one is important because it says whether the person may be eligible for a more advantageous form of leave, which would be asylum, presumably, because it says so. And so you say this policy is something really completely different from the interim period that KTT is trying to use it for.
Exactly.
Yeah.
Exactly. And so, if I may then finally come back to Lord Justice Dingemans' question, leave to remain is a UK statutory concept, and it is the means by which those who don't have the right to be here are allowed lawfully to live here. The question of whether that relates to, or how it might relate to the concept of stay, the word used in the treaty, is not immediately clear, not least because the treaty is a treaty and is not a UK statute. We say that if you read Article 14.1, it is clearly looking at situations where the individual may be entitled to permanent, or perhaps better say longer term leave, in contradistinction to the kind of purely interim procedural leave that KTT was seeking.
But your policy is for 6 months only under the DL, isn't it?
No, the policy provides normally for a grant of 30 months.
Sorry, if you get discretionary leave under the MSL policy, what do you get, 6 months?
Normally 30 months.
Is it 30 months, sorry?
Reflecting the purpose.
Where's that in the policy? Sorry, go on.
So, it's page 635.
Thank you.
So was this point made to Mr. Justice Linden that really they'd got it round their neck, and that this was addressed to a completely different situation from KTT, and or was all the argument about have you promised Article 14 or have you not promised Article 14?
No, as I recall it, there was argument addressed to this point about whether this is really the kind of necessary stay.
What did he say about it? I've forgotten.
I think if you go to the section dealing with the interpretation of 14.1a is starts paragraph 81. This is page 316 of the core bundle. And perhaps the clearest point, that there's a lot of argument set out here. If you look at the top of the 318, paragraph 86, this is argument about whether Article 14 is contemplating the kind of interim leave to pursue leave for which KTT contends.
More a point about, well, let me read it properly.
Different point, I think. See from the last sentence.
Well, if you go on to paragraph 89, sorry, his conclusions, he is looking at that phrase, their stay is necessary.
I know.
Yes.
I mean, that's what the argument seems to have been about. And even in paragraph 88, I don't see your argument recorded that what is contained in the policy concerns the period permanent, that contemplates a permanent grant of leave for people in whose favour a conclusive grounds decision has been made, not the interim period between between the conclusive grounds decision and asylum. I mean, that's a very material point, because if we go back to the policies bundle, under the heading leave is necessary owing to personal circumstances, which is what we have to look at with a fine-tooth comb, the examples are the first stage, where the first example makes it clear that if you've got a more advantageous form of leave coming up, or you've applied for one, this is not for you. I mean, it doesn't say that, but it could be construed as that, and you say it should be. but I don't see that anywhere. I've never seen that anywhere else. I mean, I'm going to look in your skeleton in a moment.
Lord, it may be that the thread of all of this has got lost. It started with the submissions that we made. Definitely did make this because he's recorded it. That if you look at the treaty and you're asking yourself, what does the treaty mean? You can't look at it with a common law statutory interpretation.
I completely get that. But the point is not that. The point is we have to look at your policy. And we are allowed to be common lawyers when looking at a policy made in a common law jurisdiction. A bit more.
Yes. Well, the policy doesn't say that this is a situation in which leave has to be granted. Because the policy is, it refers to the primary assessment to be made. And I know the court will make of that what I've made my submissions on that. But it then gives a number of examples which illuminate the object of it.
Well, if you're right, there's been an almighty mix-up as to what this policy is about. Because the policy is actually addressed to a very narrow problem in many cases. Again, we might want to know some figures, but I'm assuming that many, if not the majority, of those who get a conclusive grounds decision are also awaiting an asylum decision.
Yes, again, that I don't know.
Certainly many, if not most.
But the question as we'd understood it is, well, first of all, whether this policy is a policy which provides for the grant of interim leave, or leave of
what leave? Sorry, I just
leave of an interim nature. That's to say, leave to remain in order to pursue an application for asylum, which was the claim that KTT was making.
Yes.
Or whether this policy is directed towards granting leave on a more substantive and longer-term basis.
Well, when you say this policy, you mean the policy as spelt out in these bullet points?
Yes, that's
right. Well, that clearly, you're right about that. About that, I think, aren't you?
Yes. Well,
I don't. But the point is that is precisely because it doesn't do that.
Yeah.
That it doesn't cover a case that Article 14.1a says it should cover.
Well, we respectfully say that Article 14.1a does not.
Quite. Well, that's what the issue is.
Yes,
and you were making a point about what's meant by stay in 14.1a.
Yes.
And you were saying that can't be intended to cover an interim stay. But I'm not quite sure why you say that. I mean, you can assert it, but it's not obviously correct, particularly when 14.1b uses the same language of stay about people who are cooperating in criminal proceedings, where one would assume that once the criminal proceedings are over, 14.1b ceases to bite.
But it would not necessarily be any time soon, as we know
No.
in many of these
No.
cases. And that's why there is a need for...
Well, I mean, I may be being very stupid about this, but I don't see that the question of what stay means matters. What matters for this purpose is what this policy says, and you say this policy is addressing something completely other and different from the position in the bulk of Article 14 or from what KTT's position is, and nowhere else have you said you will comply with Article 14 simpliciter, and so what Article 14 may imply doesn't matter. I mean, I know you say, and anyway I'm right about Article 14, so we can come to that very interesting question of interpretation of treaties in due course. But even if you're wrong about that, you say, we have never given any high-level assurance that we will comply with Article 14. All we've said is we'll do this, and this is all about something else.
We've never given an assurance of sufficient specificity about complying with Article 14 itself, precisely.
Yes. Well, I mean, you haven't, all you've given is high-level blandishments which you say don't matter, and you've never said, I'm going to comply with Article 14 specifically, and therefore you're not obliged to.
Yes, well, my Lord summarises the justiciability argument in a nutshell.
Yes.
That's what I was going to get to last, but
yeah, well, justiciability is quite important,
yes.
because justiciability, I mean, Article 14 is only relevant, as we know, because of Rayner's and SC, if otherwise we're just looking at what you've promised to do in a policy.
I don't quite know why we're looking at these bullet points, because as I understand it, I've forgotten what was in Mr. Butler's first argument, he's not saying he's entitled to what he wants under the policy as drafted. He says the policy as drafted doesn't correspond to what you've promised in your overall policy. So why are we spending time going through these bullet points?
well, it makes
You're saying he doesn't qualify, and Mr. Butler's saying, yes, I know I don't qualify, that's my complaint.
yes, to make good the submission that the policy does not cover this situation, just like it does not cover the situation.
Well, I think that's the problem, isn't it? You don't need to make that good, unless I'm being over simple about this.
I'm not sure that Mr. Butler agrees with that characterisation of his case.
Oh, well, there you are. I've obviously got it wrong. So.
Well, it was a shaking of the head that I picked up more.
You see, I think Mr. Butler says, and he'll speak for himself in due course, I'm sure, but I think that Mr. Butler says that it is to be implied from the passage that I happened upon right at the beginning, namely the reference to the obligations, the Trafficking Convention, that the government was saying it would comply with it.
Oh.
And he's nodding now,
Yes.
so we've done...
Yes, I didn't mean anything different from that.
And therefore, that's a question of construction. If it's only to be inferred from this document that that's what the government is saying, then we do have to look at the whole of this passage and see what it means. Because if he's right, then it may be addressed to something completely different on a proper analysis of the bullet points, but if it's actually saying, and we will comply with Article 14, then that's a promise to victims of trafficking, and one you'll have to comply with. But you say that's all so much nonsense. It's perfect. I mean, I'm paraphrasing, but it's so much nonsense because all it says is that the decision maker has got to primarily assess whether a grant of leave to recognise victim is necessary for UK to meet its objective under the Trafficking Convention, and that objective is to provide protection and assistance to that victim owing to their personal situation. And that's our objective, the government's objective under the Trafficking Convention, and it's nothing to do with Article 14. It may have some passing similarity.
Well, the policy here, this part of the policy, clearly reflects at least some of the cases covered by Article 14(1)(a). Sorry, I use a slightly tentative language so that we're not bogged down in the extent of that. So it is not merely incidental. We say that when you look at the policy, it's quite clear what it means, the sort of situations it's directed towards. And so our argument here, and you may recognise this from where I started this morning, is first of all that Article 14(1)(a) doesn't require any more than this, because this is the kind of situation.
If you're wrong about that,
sorry.
But if you're wrong about that, it doesn't matter because this is all we've promised.
If I'm wrong about that, then there is no hook on which one could say that the Secretary of State has breached her own policy.
Yeah, it doesn't matter because this is what policy is. Yeah.
Now, it may be that if the court were to hold that this doesn't comply with Article 14(1)(a), but it's not unlawful, then there will be other consequences, not legal consequences, but there would be other consequences, and they would take their course. But as a matter of law, we would respectfully say that's not a reason for finding against the Secretary of State if in fact the policy is, as a matter of domestic law, lawful.
I think I should own up. I have just looked again at the relief below and at Mr. Butler's chosen argument, and I think he says that if he wins on whether this has to be that your policy is to comply with 14(1)(a), then the policy as it stands here can be construed as doing so. It doesn't have to be quashed and you have to make a new one which will either have to be compliant or not. Depending on what you choose. So I think what I suggested earlier was a bit of a red herring on that point. Mr. Butler thinks I wrote it right this time. It would presumably be a possible fallback, but not one he really needs, because Mr. Justice Linden accepted that line of argument, that even if it really can't be construed in that way, then they've got to go away and think about it again. Thank you.
Yes, I don't think I can usually add anything at that point, on that point at the moment.
Just before we leave that, can I just ask a question of where we are on the facts? There is an outstanding claim to the FTT at the moment, is there, in KTT?
Yes, I believe that's right.
Is there a date for that?
I don't know. Just have a moment. Okay, we'll find out.
Right. Sorry, it's only a point of detail.
Yes. I think that the point at which I diverged from what I was going to say in answer to Lord Justice Dingemans is that we do say that applying the proper approach to reading a treaty, it would not be right to read stay in either 1A or 1B, but for these purposes it's 1A that matters, to read stay as referring to any interim period in which somebody is irremovable. Because reading 14(1)(a) as a whole, that's including the body of 14(1), the contemplation is clearly that there is some longer-term need, and not just an interim period of irremovability pending the decision on the asylum.
We just test that about another kind of personal need. Suppose a victim of trafficking is undergoing some finite but lengthy medical treatment. I'm not sure it's logically necessary the treatment should be required as a result of their experiences of trafficking, but necessary assume that too. Mightn't 14.1a mean that until that treatment is over, you have a personal need to stay in the UK, and you must be given a residence permit for that purpose? But once you have been successfully cured, is the end expected in 6 months or a year's time, then the obligation to give you a residence permit ceases. What would be your position on whether that was covered by the concept of stay?
Potentially covered by the concept of stay, and it is potentially covered by the policy itself.
All right, I'm dealing with your, because I thought what you were saying about stay is that it couldn't apply to something that was purely interim or short term. I forget, I think you used the phrase.
I use the word interim to try and distinguish it from the sort of substantive need that one sees described in the bullet points and then further on about medical treatment. And there is an analogy within ECAT itself concerning this sort of interim need, which is the potential victim, so the positive reasonable grounds decision, equally irremovable from the UK, and in one use of language needs to stay here until it has been determined whether they are or are not a victim of trafficking. In a very similar position to the asylum seeker. And yet the one thing that is clear is that ECAT does not provide for a residence permit to a potential victim, subject to anything that learned friend Miss Weston may persuade the court of.
Could I just ask you about the word renewable? We've talked about residence permit. It says it should be renewable. What's the force of that?
I don't know that that's been tested. We have our own domestic policy, as you've seen, 30 months as a normal grant of leave. If you still need leave at that point, on this ground or on some other ground, you may get an extension. And the reality is that if you have enough time, you'll go on to other forms of leave that are provided for in the immigration rules that are nothing to do with trafficking.
But the convention obviously hasn't got the British system specifically in mind.
Precisely.
I mean, the point my lord may be driving at is renewable indicates a level of permanence.
Or does it?
Well, it indicates a level of temporary or shorter in the first instance, but it must be renewable, which is not talking about an interim period. That would be the point you'd make.
Yeah, but that is indeed what I was wondering about. I've just looked at the explanatory report. The only bit I've found is para 188, which is at page 623. Which says, even though the convention does not specify any length of residence permit, it does provide that the permit has to be renewable. And then it refers to para 3 of Article 14, which we haven't yet looked at, which says that the non-renewal of a residence permit is subject to conditions provided for by the internal law of the party. It's all rather opaque to me.
But I mean, one important part of this is the scheme of Part 3. I mean, I know everybody's alluded to that, and you have particularly, Mr. Tam, but it is perfectly clear anyway to me that there is a scheme to Part 3, which is under the heading Measures to Protect and Promote the Rights of Victims, guaranteeing gender equality, and it starts with identification, as you've pointed out, what goes into that. It then talks about protection of private life and identity data, and then it talks about what assistance they shall have to assist their recovery, and different measures if they're lawfully resident or not. And then we have the much vexed question of Article 13.1 and my Lord's construction of it, and it's completely impenetrable in my view, but it is about the recovery and reflection period. Certainly it's about interim, and then we come to residence permit, which indicates quite clearly some kind of permanence. And then we come to compensation and legal redress, which is the end of it all. So, I mean, there is a certain coherence to the structure, and I think, so far as I'm concerned anyway, the words renewable resident permit, to me, also indicates some kind of permanence. I mean, it doesn't mean that it couldn't be used for an interim period, or doesn't imply an interim period. But it's certainly looking also, at the very least, at a longer term period.
I mean, residence permit, I would have thought in European, this is a European convention, understanding, means essentially that you are lawfully present in the country and can take advantage of all the rights available to residents. Work, crucially, but no doubt rights to benefits as well. To me, although the word renewable might add an extra element, if it was just residence permit, I would have thought that implied nothing particularly about permanence. It was more about the status while you were there. But the word renewable, as my Lord says, does suggest at least indefiniteness, if not permanence, if there's a distinction. But I don't feel I have any feel what the draftsmen of the convention, drafters of the convention, really had in mind. Whether once you got one of these, effectively you could only be removed for good cause. I don't know. They talk about your internal law, but they must have had some general idea what the internal law was likely to say about people who were had a residence permit.
Well, Lord, my submission about renewal and the concept of renewal is that it supports the submission we make, which is that Article 14.1 is contemplating a longer term form of leave.
Longer term.
In contradistinction to leave in order to apply for leave, which is what KTT wants, where neither this convention nor the Refugee Convention provide for it within their own respective structures.
So that may be a good moment to break.
Lord, I'm grateful. I do have just one piece of information, which is the FTT hearing is scheduled for the 23rd of February.
Thank you.
Sorry, I thought that it was a...
But there's a case management hearing on the 23rd of February, so it's in the scheme. Yeah. Okay.
Perhaps after lunch, if I don't find it during lunch, you will be able to tell us where in the skeleton argument the point that you have just been discussing with the last 20 minutes or so about what exactly stay means appears.
Good, 2 o'clock.